Attorney General Lynn Fitch. Your call is very important to us, and we would like to route you to the appropriate division as quickly as possible for assistance. Please listen to all its options to find the one that best fits your needs. If you have a complaint related to identity theft, a scam or fraud, robocall, or other consumer matters, press 1. Good afternoon. Thank you for calling the Office of the Attorney General. This is Kimberly. How may I help you?
Hey, Kimberly, I'd like to report fraud, scam.
Okay. Can I have your first and last name, please?
Yeah, it's Matt Reardon, R-E-A-R-D-O-N.
I'm sorry, R-E?
R-E-A-R-D-O-N.
Okay. And what's the scam, please?
What's the what?
The scam, you said?
Yeah, it's Lafayette County Sheriff's Department. They're up to no good. Lynn Fitch's office is well aware of. I'm in the Court of Appeals right now. I was framed back in 2017 by the local government, particularly the Sheriff's Department, for a crime which never even occurred. It's part of an election scandal. This goes even deeper because I did a 1.5-year investigation in the county when I couldn't get anybody else to conduct any investigation. And what I discovered was shocking. I was retaliated upon by the Lafayette County Sheriff's Department. I have 9 charges against me that I'm standing trial for in justice court from 3 separate events. That it's corruption galore. I've captured it on audio and video, and there are 2 different cameras, not 1 but 2, from 2 separate arrests that have mysteriously grown 2 legs and disappeared in the Sheriff's Department's custody, and they're expecting me to stand trial, not even getting a jury trial. And these 2 definitely very relative cameras are just missing in action, and I think there needs to definitely be a probe into the Sheriff's Department.
Okay, sir. First of all, I'll have to transfer you to our Public Integrity Division.
I've talked to him. I don't know.
Miss Johnny.
Yes.
It's Matt Reardon.
Hi.
How are you?
All right.
Well, I got something that's on my mind. Really bothering me. The fact that I submitted a pauper's oath on this last appeal. Okay, it's something that quite frankly it needs to be addressed. It's gone way overboard, and the judges were out until late Friday. The judge that I had done the appeal on and submitted a petition for writ of mandamus to the Supreme Court was actually the one to rule on my pauper's oath and actually denied it when I don't have a pot to piss in because I've literally been fighting for my life and like I've had to fight in 6 different courts. It's destroyed my earning ability. My employment was targeted. My wife's was targeted, and I don't know what to do. They submitted it. The judge signed off and said it's denied, even though there was no reason it should have ever been denied. And I definitely can't afford to pay the filing fee. And I don't think that he should have ruled on it if he was just going to flat out deny it like that. That's just crazy all the way around. I mean, that's stacked. You can't tell me that's not stacked. That's unfair.
I can't tell you anything, Mr. Reardon.
I understand you can't, but I'm just saying the deck is stacked, and that's super unfair.
Okay. All I can tell you is if you want to file something with the court, we'll be happy to file it for you. I don't know what to say for you.
I'll file something else on him. I guess I'll file something else on him. Did y'all get the pauper's oath sent over today?
Yes. trial court order denying my he came over.
Yeah, that is just, I've never seen something just so corrupt in my life as what's been going on here in North Mississippi. Hopefully somebody can deal some change to it, because I'm a Marine Corps veteran. I swore a lifelong oath to protect and defend the Constitution. This is not the way the legal system's supposed to work.
Okay. Like I said, if you want, anything that you want to find here, we file it. We just not, I just don't know what to tell you about.
I just didn't know how often you saw the same judge that something's filed on rule against the pauper's oath.
We have 82 counties, and
I still think it's probably pretty rare.
Just in cases, I mean, we don't notice every ruling that comes through here.
I understand.
Yeah.
Okay.
Okay.
All right. Well, I'll get something put together. Really, we're at a time crunch because of the, it's already past the 7 days, and then the judge just denied the pauper's oath.
Well, there's a 5-page limitation on any faxes that come in.
Okay, yeah, I'll keep it less than that. I mean, I honestly don't have the time to write any more than that, as stretched out as I am. I have trial on 9 different charges that were retaliatory on Thursday, just from conducting an investigation into the county. All right, Miss Johnny, I appreciate it. I'm sorry to have negged out to you, but that was beyond bizarre.
Okay, thank you, Mr. Reardon.
Thank you. This is the way they treat me at the Attorney General's Office, Public Integrity Division. I believe their Public Integrity Division needs a Public Integrity Division.
In the Supreme Court for the state of Mississippi, Matthew Oliver Reardon, the appellant, versus Phyllis Murray Crowder, the appellee. This is the petition for writ of prohibition.
To be directed to the trial judge comes now your appellant, Matthew Oliver Reardon, and respectfully prays that this honorable court, through much needed intervention now sought into the above styled matter, issue a writ of prohibition to be directed to the trial judge, while simultaneously granting appellant's previous petition request for a writ of mandamus. At this particular stage, and with the combination of both petitions respectfully requested by appellant for the reasons stated in this petition, the prior petition, the writ of mandamus, and the notice of appeal, and the seriousness of all ongoing legal matters which continue to show is interlinked and connected through one way or through multiple ways, appellant feels that it would be a justifiable and fitting request for this court to enter a preliminary injunction for relief into the matter until further order of the court, in order to get the major grievances at hand addressed and sorted out. Appellant states his reasons for application for such petition is listed in Canon 2 and Canon 3 of the Code of Judicial Conduct, and appellant would list those specific grievances out as the following. 1. A judge must avoid lending the prestige of judicial office for the advancement of the private interest of others. For example, a judge must not use the judge's judicial position to gain advantage in a civil suit. A. Appellant states that pursuant to the combined notice of appeal and petition for writ of mandamus filed on 10/12/2021, the trial judge at that point had an obligation to recuse from any further proceedings as civil litigation was commencing before the Mississippi Supreme Court on the reference cause, notice, and petition. B. Due to the combination of a plethora of concurrent legal matters that have hurled themselves at the appellant and his spouse parenting 3 minor children full-time, and the fact that appellant's earnings potential continues to get targeted and chipped away through one form or another, appellant has had to file various petitions and documents in multiple courts under pauper's oath. This being no different, in order to not prejudicially be disadvantaged even further and the likelihood of suffering even more irreparable damages. C. That on Friday, 10/29/2021, this very trial judge denied appellant's informal pauperous petition without giving any written response or reason for denial. Appellant feels that a denial of a pauper's oath in non-contested matters without any justifying reason or written response given by the trial judge should be alarming as is, due to the unfair advantage levied against the party aggrieved by the cost of mandatory filing fees, particularly in extraordinary situations. However, alarming doesn't even come close. In this particular situation that appellant would reference to as nothing short of appalling, in order to weigh strategic advantage towards the appellee and this trial judge due to the bizarre nature of the current events which fall out of the appellant's control. Appellant further states that on multiple occasions the trial judge was made aware that the current obligations for child support were far outside of the justifiable range of 14% adjusted gross income. Not to mention, the minor child had immorally been ripped away from her father due to the bizarre, contumacious actions of the minor child's mother, whom is your appellee in this matter. 2. A judge shall hear and decide all assigned matters within the judge's jurisdiction except those in which disqualification is required. Code of Judicial Conduct, Canon 3B1. A. Disqualification in this cause came into effect when appellant filed his notice of appeal and petition for writ of mandamus on 10/12/2021. B. On the aforementioned date, 10/12/2021, not only was disqualification required due to the pending writ of mandamus petition for by the appellant, but the jurisdiction for this particular grievance at hand shifted from the Chancery Court of Lafayette County to the Mississippi Supreme Court. 3. A judge shall be faithful to the law and maintain professional competence in it. A judge shall not be swayed by partisan interest, public clamor, or fear of criticism. Code of Judicial Conduct, Canon 3B2. A. Over and over again in motions, appellant has stated he felt he wasn't afforded a fair hearing guaranteed through established, well-settled law, Article 3 of the Mississippi Bill of Rights, as well as the federal Constitution. In that time and time again, he was being mandated to prove his absolute innocence 100%, while appellee continued to be taken at her word despite having a proven track record of falsely accusing the appellant of crimes in order to immorally keep full control and custody of the minor child. 4. A judge shall perform judicial duties without bias or prejudice. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice. A. Appellant states the trial judge's denial of his informal pauperous petition has taken the shape and form of prejudicial and biased treatment, most certainly when assessing the true history of this cause stemming back to May 1st, 2017. 5. Judges should disqualify themselves in proceedings in which their impartiality might be questioned by a reasonable person, knowing all the circumstances or for other grounds provided in the Code of Judicial Conduct, or otherwise as provided by law. Code of Judicial Conduct, Canon 3E2. A. Under this rule, a judge should disqualify himself or herself whenever the judge's impartiality might be questioned by a reasonable person, knowing all the circumstances, regardless whether any of the specific rules in Section 3E1 apply. 6. A judge must perform judicial duties impartially and fairly. A judge who manifests bias on any basis in proceedings impairs the fairness of the proceedings and brings the judiciary into disrepute. The issuance of a writ of prohibition, while considered to be a common law remedy, is governed by ubi jus ibi remedium and the equitable principle that there is no wrong without a remedy. The function of the writ of prohibition has been extended to cover situations where even though the inferior court has jurisdiction, the superior court deems it necessary and advisable to issue the writ to prevent some palpable and irremediable injustice. Planners Insurance Co. v. Kramer. The writ has also been issued to restrain a judge from proceeding in a case which he is disqualified to sit. Peters v. Jameson. without waiving away any of his rights. Appellant hereby makes notice, reserves and preserves his rights to a takings claim under the England-Jennings Reservation, which allows for remedy to grievances and damages due a takings claim, utilizing the federal courts in the absence of proper and sufficient redress not obtained in the state courts without such action being barred by way of res judicata or collateral estoppel. Respectfully submitted this second day of November 2021. Matthew Reardon, the appellant, and the Oxford Outlaw.
When freedom is outlawed, only the outlaws will be free.